The government owned a 12-hectare land in Cavite classified as forest land. Informal settlers built shanty houses on the land since it was flat, and there were no trees planted thereon. In 2023, the government decided to plant Nara trees on the land and demanded that the informal settlers vacate the same. A owner of one of the shanty houses refused, claiming that he already owned the portion of the property he was occupying by virtue of acquisitive prescription. Is the claim of a meritorious? Decide with reasons. A's claim of ownership by acquisitive prescription is unmeritorious. Under Article 1113 and Article 422 of the Civil Code, prescription cannot run against public dominion property that has not been converted into patrimonial, alienable property. The Supreme Court has consistently held that public domain lands, including forest/timber lands, that have not been converted into patrimonial property cannot be acquired by prescription, and long possession by private persons does not vest ownership against the state absent lawful reclassification/disposition. The land in question is explicitly classified as forest land and is described as government-owned. Forest, timber, land falls squarely within the public domain, lands intended for public use or for the development of the national wealth, and unless and until reclassified, is inalienable and not subject to prescription. The government's 2023 decision to plant Nara trees and its demand that informal settlers vacate the area are affirmative acts showing that the land remains under state control and intended for public/forest purposes. Thus, even if A and other settlers built shanties and continuously occupied their respective lots, such possession cannot mature into title by acquisitive prescription against government forest land, making their claim of ownership unmeritorious.